The ownership illusion. What you think you own, and what the law actually says. Open your brokerage account right now. Look at that number on the screen. The stocks, the bonds, the retirement savings you have spent years building. Now ask yourself one question. Do you actually own that? Not emotionally. Not in the way your financial advisor describes it, legally, technically, in the precise language of property law. Do those assets belong to you? The answer, buried inside a legal framework most people have never heard of, is more complicated than you have been led to believe. And the implications of that answer, in the event of a major financial crisis, could determine whether you keep what you have spent a lifetime accumulating. This is not speculation. This is not conspiracy. This is what the law actually says. Part 1. The legal shift from owner to entitlement holder. To understand what happened, you need to understand what ownership used to mean. 100 years ago, if you owned a share of stock, you held a physical certificate, a piece of paper with your name on it, a legal document that represented a direct claim on a portion of a company. If that company's bank failed, your certificate still existed. Your ownership was not dependent on any intermediary remaining solvent. You were the owner, legally, unambiguously, on paper. Then the financial system scaled. By the 1960s, trading volumes on American stock exchanges had grown so large that the paperwork became physically unmanageable. Certificates were being lost. Settlement was taking weeks. The system was choking on paper. The solution, developed over the following decades, was centralization. Instead of millions of individual investors holding millions of individual certificates, a single central entity would hold all the certificates. Investors would hold electronic records showing their claim against that central entity. The Depository Trust Company, the DTC, was established in 1973 to serve this function in the United States. Similar institutions were established in countries around the world. Suddenly, the vast majority of securities in existence were held in the name of one entity, the DTC, or its nominee, C-Day & Company. Your brokerage held a claim against the DTC. You held a claim against your brokerage. The certificates still existed, but your name was no longer on them. For decades, this arrangement functioned without most investors giving it a second thought. The electronic records showed your holdings, dividends were credited, votes were cast on your behalf. The practical experience of ownership appeared unchanged, but something significant had shifted at the legal level. And in 1994, that shift was formalized in language that most people have never read. The Uniform Commercial Code, the UCC, is the legal framework that governs commercial transactions across the United States. In 1994, Article 8 of the UCC was revised to address the new reality of securities held through intermediaries. The revision introduced a new legal category, the security entitlement. Under the revised Article 8, an investor who holds securities through a broker does not hold the securities directly. The investor holds a security entitlement, a bundle of rights against the broker, who holds a security entitlement against the clearinghouse, which holds the actual securities. The word entitlement is important. It is not ownership in the traditional sense. It is a contractual right, a claim, a position in a legal hierarchy. Legal scholars and financial experts who have examined this framework carefully note that this distinction matters most not during normal times, when the difference between a security entitlement and direct ownership is functionally invisible, but during periods of extreme financial stress. During a crisis, legal hierarchies determine who gets what. And under the framework established by UCC Article 8, retail investors, the people whose retirement savings are represented by those numbers on a screen, are not at the top of that hierarchy. Part 2. The structural danger. Who gets paid first? To understand the structural vulnerability, you need to understand one legal concept: secured creditor. In any bankruptcy or insolvency proceeding, not all creditors are equal. Secured creditors, those whose claims are backed by specific collateral, have legal priority over unsecured creditors. They get paid first. Whatever remains after secured creditors are satisfied goes to everyone else. This is not controversial. It is standard bankruptcy law, recognized in virtually every legal system in the world. The question that concerns legal scholars is where retail investors sit in this hierarchy when a major financial intermediary, a large broker, a clearinghouse, encounters a solvency crisis. Under the UCC Article 8 framework, the assets held by a broker on behalf of its customers are supposed to be held separately from the broker's own assets. This customer property protection is a foundational principle of securities regulation, but the implementation of that principle involves layers of legal complexity that create genuine structural questions. Here is the concern that experts raise. Major financial institutions, banks, broker-dealers, routinely use securities as collateral for their own borrowing. This practice, called rehypothecation, allows an institution that holds customer securities to pledge those same securities as collateral for the institution's own financing arrangements. The customer's securities support the institution's balance sheet. In normal times, this creates no visible problem. The institution remains solvent, the collateral arrangements are managed, and customer accounts show the correct balances. In a scenario where a major institution becomes insolvent rapidly, the kind of rapid cascading insolvency that financial crises can produce, the legal untangling of what belongs to customers and what has been pledged as institutional collateral becomes extraordinarily complex. The secured creditors of the institution, the large banks and financial counterparties that hold collateral agreements, have legally enforceable priority claims. Their claims are secured. The retail investor's claim, as a security entitlement holder, sits in a different and more complex legal position. David Rogers Webb, a former hedge fund manager who wrote extensively on this topic, argues that the legal architecture created by UCC Article 8 and its global equivalents systematically prioritizes institutional secured creditors over retail investors in a collapse scenario. Most mainstream legal scholars do not accept the most extreme version of this argument. They point to customer protection regulations, SIPC insurance in the United States, and the legal firewalls that separate customer assets from institutional assets as meaningful protections. But even scholars who dispute the most alarming interpretations of the framework acknowledge the underlying structural reality. In a sufficiently severe financial crisis, the legal mechanisms that are supposed to protect retail investors would be tested under conditions they have never actually faced. The 2008 financial crisis came close. The collapse of Lehman Brothers created exactly the kind of complex, multi-layered insolvency that tests these legal structures. Lehman's bankruptcy proceedings took years to resolve. Customers of Lehman's brokerage arm faced temporary account freezes and extended uncertainty about their positions. The system held, largely, because regulators intervened aggressively to prevent a complete cascade failure. Government backstops prevented the customer's securities support the institution's balance sheet. In normal times, this creates no visible problem. The institution remains solvent, the collateral arrangements are managed, and customer accounts show the correct balances. In a scenario where a major institution becomes insolvent rapidly, the kind of rapid, cascading insolvency that financial crises can produce, the legal untangling of what belongs to customers and what has been pledged as institutional collateral becomes extraordinarily complex. Scenario, from escalating to the point where the deepest questions about UCC Article 8 would have needed definitive answers. But government intervention is not a law of physics. It is a policy choice. It requires political will, institutional capacity, and resources. In a sufficiently large and rapid collapse, the question of whether intervention arrives fast enough and whether it is large enough is genuinely open. That is the structural danger, not a guaranteed outcome, not a planned confiscation. A legal architecture that, under extreme stress, places retail investors in a more legally vulnerable position than most of them understand. Cui bono. Who benefits from this architecture? The institutions that benefit most directly from the current system are the large financial intermediaries whose own financing arrangements are supported by access to the securities held in the centralized custodial system. They helped design the legal framework through their lobbying and legal representation in the UCC revision process of the 1990s. They understood what was being created. Most retail investors did not. This is not a claim that the revision was a conspiracy. Legal frameworks evolve through complex processes involving many interests. But it is accurate to note that the parties with the most sophisticated understanding of the legal implications of the revision were the institutional parties. And those parties benefited from the legal architecture that resulted. Part 3. What this means. There are two responses to this information. The first is dismissal. The legal protections are real. SIPC insures brokerage accounts. Regulations require customer asset segregation. The system has survived multiple crises. The doomsday scenario has not materialized. This response has merit. The legal protections that exist are not nothing. They represent genuine regulatory effort to address exactly the vulnerabilities that the UCC Article 8 framework created. The second response is the one that this framework demands. If you think carefully about what you have just heard, every legal protection is a promise. Promises are only as reliable as the conditions under which they were made. SIPC insurance covers up to $500,000 per account. It is funded by assessments on broker-dealers, not by the government directly. In a scenario where multiple major broker-dealers fail simultaneously, the adequacy of that fund is an open question. Customer asset segregation requirements are real, and they are enforced. But the mechanics of rehypothecation, the complexity of multi-layered custodial arrangements, and the speed at which modern financial crises can develop create conditions where even well-intentioned regulatory frameworks are tested in ways their designers did not fully anticipate. The numbers on your screen are not nothing, but they are not what most people believe them to be. They are entitlements, claims, legal positions in a hierarchy whose full implications only become visible under conditions of extreme stress. Understanding that distinction is not a reason to panic. It is not a reason to liquidate everything and bury cash in your garden. It is a reason to understand what you actually own, what protections actually exist, and what questions you should be asking about the structure of your own financial life. The people who design financial systems understand the legal architecture of those systems precisely. The people who use those systems are rarely given the same level of clarity. That asymmetry of understanding is not accidental, and closing it, one uncomfortable truth at a time, is the only meaningful defense available to anyone operating within a system they did not design and cannot individually change. In 1929, people believed their money was safe in the bank. 9,000 banks later, they understood something different, not because the banks were dishonest, because the legal and structural reality of what safe in the bank actually meant had never been fully explained to them. The numbers on your screen represent real value, real savings, real years of real work. They also represent a legal position whose full implications most people have never examined. That gap between what people believe they own and what the law says they actually hold is one of the most consequential pieces of financial literacy that the current system does not volunteer. Now, you have heard it. What you do with it is your decision. If this gave you a new perspective, subscribe to Economic Chronicles, the hidden architecture of money and power. We show you where to look,